Thank you very much. I'm delighted to be here, and my thanks to Jules and to the Privacy Forum and the Goethe-Institut. So I'm going to do my best to accomplish a little bit of what Andrea Glorioso was talking about earlier as his occupation of kind of translating between the two legal cultures that are European and American, by trying to give you a little bit about French legal culture. Some aspects of it you've heard about because France is a civil law legal system, just as Spain is. In many ways, French legal culture is almost the converse of the US legal culture, even though the founding fathers were influenced by many of the same people who influenced the French legal system. So, for example, one of our colleagues earlier mentioned a few times Montesquieu. He was a big influence on the US founding fathers. Rousseau, Condorcet, all of these people influenced. They were called the philosophers, les philosophes of the 18th century, the pre-revolutionary people who influenced the revolutionaries in France. Same thing with the US founding fathers. So on the other hand, the way that that these ideas developed in each of the countries was very different. That had to do with the politics, the societies. It was the way that these ideas were transplanted into the United States. Legal system was very different. So French law developed from Roman law. Roman law was rediscovered in Europe at the time as Europe was emerging from the Middle Ages. And in fact, the British also rediscovered Roman law. Roman law was taken back to England as well, but it wasn't what's called received in England, but because they already had a very highly functioning legal system. The common law was what was at work there, and so Roman law never took hold in practice. It did in the universities, but not in practice. Whereas Roman law became the basis for law in all of the continental European countries, which, as you heard the term before, they're called the civil law legal systems, which have civil law legal systems. So what distinguishes the two? To be a bit simplistic, Roman law was based, and the continental European systems, legal systems, are based on a civil code. So we say they are codified legal systems. And the first great modern civil code was the French civil code, the Napoleonic Code. The second one you'll be hearing about, no doubt, after I end my presentation. So the principal drafter of the French civil code was Portalis, and he understood from the beginning that if this French civil code was to last and to be successful, he understood that it would have to be drafted in general terms, not specific detailed terms. And this was, in fact, the triumph of the French civil code. And so that's what happened. So as a consequence, the French legal mind thinks in terms of general legal principles. Legal principles that are derived from the civil code that are to be applied deductively to whatever litigation may be brought to court. And other consequences. Law, the idea of what law is always textual. It's always written. So US law was, as I mentioned, the common law. And what that meant is judge-created law. So the norm in the United States, whether we have a statute or not that ends up governing, the mentality of what law is that judges create law case by case by case. So what they create are these tiny mini laws, the law of the case, the rule of the case, but that's how they're developed. And so instead of thinking deductively, in the United States, the legal mentality is inferential. It's not deductive, it's inferential. We think inferentially. Judges decide cases before them by analogizing from case to case the factual and legal details of the case that's pending to those of cases that have preceded, of the body of cases that have preceded. And so even if a statute exists that governs it, they don't think deductively. Now, in France, judges never create the law. You saw a slide earlier about the separation of powers under Montesquieu. Well, one of the things that did not come through is that the judiciary is an inferior power. In fact, in France, you speak of two powers, the executive and the legislative. And the judiciary is called une autorité, an authority. It's not even a third power. So it's a really, and that's the idea of Montesquieu, that the judges are just the mouthpiece of the law. All they do is apply the law. They can never create it. So, so this is exactly the converse of the United States. Implicit in the idea of what a judge does, namely to take the legal principle from the code, to apply it correctly to the case at bar, is the idea that there is such a thing as one and only one correct solution to every problem. And that what it means to be a good judge is to be able to identify what that one and only one correct solution is. So in the United States, laws are sort of the opposite of what they are in France. They're not enacted as general guidelines. They're not enacted as general guidelines that precede the problem that arises. They're enacted as a result of the problem that arises. So if the public, if constituents have noticed a problem in society, they ask their legislators to enact the solution through a very narrowly drafted text of law. If the courts, in the views of the constituents, have mishandled a situation or ruling in a way that people are dissatisfied with, they go to their legislators and say, fix this. And the legislators then will draft something in a precise, detailed manner with great specificities that only lawyers can read. And this contrast between the way of drafting is also seen in contracts. So when you have the civil law business person having to contract with a common law business person, you also have a real gap. I'm not going to get into contracts and the problems that can arise with the meeting of those two, but there's significant situations of incomprehension that arise there. So in contrast, the French Civil Code is not evolving case to case. The idea is the Civil Code is static. It's not fluid. It's eternal in theory. It's also a stylistic and linguistic masterpiece. So French novelists have gone to bed after reading an article or two of the Civil Code. They said novelists like Balzac or Stendhal would say that they got inspired from the language, the beauty of the French Civil Code. But the idea of the revolutionaries who overthrew the king is that you didn't need to be an aristocrat to understand the law that governed you. Every French citizen could understand the French Civil Code, drafted in these general terms, in these limpid terms, language that was available to all. It's a little red book, like a Mao's little red book. You can buy it in every bookstore. Every French household has this French Civil Code. I take it down to my classes to show this is the French Civil Code. And even that is 10 times the real French Civil Code because mine is annotated. But if you read it, if you read the articles, you will understand everything it says. But in fact, you won't really understand. So for example, if you look at one of only 5 total articles that exist in the French Civil Code that govern all of tort law, the article says, he who causes harm must compensate for the harm he causes. That's one of 5 articles. So anyone can understand that. And everyone does and feels, you know, I know my law. I know what governs me. And that makes such sense. But in fact, if you're a lawyer and you are representing someone in a case, you're going to need to read volumes and volumes and volumes of what really is going to affect scholarly treatises and annotated cases to understand how to represent a specific client in a specific situation in court. So maybe the best takeaway from all of this in a nutshell is that in France the focus will be on the general, the unified, the idea of scientific deduction, absolute truth, whereas in the United States it will be on the individual, the particular, the argument, not truth but argument, on the particularity of facts, on fluidity and motion. And the physicist Freeman Dyson made the same comparison that I'm making with science, with continental European science, which he said their method is based on theories of universality of knowledge and deduction, whereas the Anglo-American methodology is based on empiricism and particularity. And so really this is a culture that is quite a bit broader than just the legal culture, because legal culture is part of a much broader culture. So because we are here in a privacy forum, I thought I would speak a little bit about some privacy issues and under French law, and hope that that interests you a bit. So French law protects what is considered the private sphere of life in a way that US law does not. And you may know more about this than I do because you seem to be quite steeped in EU law. In the US, a public figure, for example, has very little recourse if he or she is photographed without consent. In Europe and in France, a well-known politician will be able to win her lawsuit against a magazine for having been photographed on vacation with her family on the ground that this is an intrusion into her private sphere of life. So this has happened in numerous cases. One in particular that I'm thinking was that of Ségolène Royal. You may have heard of her. She was the 30-year companion of the current president of France, and she's in her own right a prominent politician, filmed on the beach with her children on vacation, sued Paris Match, won her lawsuit. So it is not at all unusual for the right of privacy to trump expressional and informational interests. Privacy rights are defined as the right of the personality. So this is really captured in the German term Persönlichkeit. And they include the author's moral right to his or her work. This includes the right to withdraw one's work from publication, to make one's work respected, to have one's name associated with one's work, and to have the public learn of one's work. But a key point is that these rights cannot be waived, even if contractually. So that means if you make a contract, if a person makes a contract getting money in exchange for ceding these rights, they haven't ceded it. That is voidable. And so, for example, there was a case in which a French actress posed nude in a movie and later presumably this transaction was made for money in the initial contract, then was able later, by going to court, to suppress the nude scenes from the movie because that intruded on an inalienable right of privacy. So, where facts are considered to belong to a person's private sphere, and where they are divulged, truth is not a defense. Unlike in the United States, even where the person has divulged the facts about his private life himself, the information that a third party is publicizing, that same information, the third party is not allowed to publicize. Because under French privacy law, each French person is entitled to have control over when, if, and the manner in which the facts are divulged. So for example, there was a French court case in which a man participated in a gay parade, and he was dressed in such a way as to make it clear that he was gay. And then a newspaper was going to publish a photograph of him, and he went to court to have this suppressed, and was successful because the court said the fact that he had divulged this information himself, living openly as a gay person, in some ways didn't mean that he wanted everybody to know this, and he had a right to have this divulged to one community, but not necessarily to the whole world. And there was quite a similar case in the United States, which was held in the opposite way. So today, as you may imagine, the internet is posing a challenge to French law. In one case in which we can see this, the family of the late President Mitterrand went to court to stop the publication of a book that it said violated its privacy. So under American First Amendment law, this would not be the case. And so the court applied what is an institution that is Franco-French, doesn't exist anywhere else, called the astreinte, and said there would be a $200 charge on every book published in the future. And so they stopped publishing this, and instead the work was made available from a server in America, in the United States, which French net surfers could have access to. So in a case like this, invasion of privacy suits would be actionable in France. So the US, parties in the US who made this accessible would be liable in France under this decision. So you probably are all aware of the Yahoo decision. That would not cover such defendants because that only applies in the United States. So one might wonder, what are the French courts hoping to accomplish when they enjoin publications which the internet will nevertheless give access to worldwide? And one answer that has been given is human dignity, à la française, in the French spirit of things, which I think is not so far off from the German spirit of things. Honor, and the idea that even if it's not a reality anymore, that the individual has a right to personal privacy, the right to personality, which is entrenched in European Union law now through the European Court of Human Rights. So I thought you might also be interested in hearing about some transnational litigation cases and privacy issues that arise once parties go to litigation. One of the big issues that the United States and French parties struggle over is United States pretrial discovery. How many of you are lawyers in this audience? Oh, so many, many. Okay, I hope I'm not pitching this at too low a level then. But in any, you only know privacy. Okay. So
I was surprised they revealed their identity even.
Okay, but anyway, I'm among friends. You may have heard a lot of anti-French remarks earlier then, but I won't hear any lawyer jokes. Giscard d'Estaing jokes maybe, but not lawyer jokes anyway. So, okay, so discovery is, so you all know what discovery is, and the huge amount of investigating that discovery permits, even after the amended rules of December 2015, are just considered to be a tremendous invasion of privacy in France, so much so that the French Parliament passed a law called the blocking statute. And it forbids compliance with US-style discovery. Many European countries have passed similar blocking statutes. Germany, not an actual statute, but even though it's now through its revised civil procedure trying to sort of come to terms with it, has basically the equivalent of a blocking statute. So the problem is that discovery, as you know, has become such a fundamental right in the United States that many people speak of it as a constitutional right. Certainly it is a quasi-constitutional right. So American judges feel that they must protect this fundamental right of US citizens, of US parties, to conduct discovery. In France, everything is different. The whole system is so totally different. Even to call the French word for trial a trial is a total misnomer. The word is procès. It's a process. It's not a trial. So anyway, in France, only judges are allowed to question witnesses. It's a serious breach of ethics for a lawyer to approach a witness. It's witness tampering. In addition, another sacrosanct principle in France and most civil law countries is that U.S. discovery violates the principle that no party has any obligation to assist another party in litigation once litigation starts. And despite the fact that in France there's much more of a sense that everybody is searching for the truth, everybody's cooperating, but one party doesn't make the other party's case. So in France and most civil law countries, if a party wants to have a document, that only is going to happen if the party already knows the document exists and asks the judge. The party must go to the judge and say, please ask the other party to disclose such and such a document. They need to describe the document with great specificity and explain to the judge why they need to rely on this document to make their case. This is, as you know, a very far cry from what the French call, and many of us call, the fishing expeditions of US lawyers who will ask for any and all documents in their possession concerning widely defined events, and where e-discovery today can involve millions of documents in a given case. So while French concepts of privacy are offended by US discovery, US judges have been almost uniformly hostile to French blocking statutes and have ignored them. Ignored them, although they're raised by the French parties in cases where they are trying not to comply with discovery. They will say, I'm not allowed under French criminal law, under pain of criminal sanctions, to comply with discovery. And the American courts will say, too bad, so sad. We don't believe you. Those blocking statutes were only enacted to begin with to thwart the jurisdiction of the American courts. And now there is a whole body of case law in the United States that says that. And so that has been the basically unanimous reaction of the US courts, even by judges where you know, where I, for example, know the judge and know that the judge understands French legal culture quite a bit. So that's for the transnational litigation in the courts. But actually, transnational litigation today, as many of you probably also know, most cases that are transnational don't get resolved in courts, but go to international arbitration. And this is where you have a party from a common law system and a civil law system. You have the meeting of these two legal systems in the arbitral tribunal. And arbitration is making compromises and to accommodate these systems, but there's still a lot of kinks to be worked out. And one particularly thorny issue in international arbitration, where one party is American and one party is French, is the issue of the attorney-client privilege. They are completely different conceptions in both systems. And what is true for the French system is largely true for many civil law systems. In the United States, the privilege is meant to promote ease of communication between the attorney and the client, because it ensures that these communications will not be subject to discovery, and also that they will not be admissible as evidence in any proceeding. So in the US, the privilege is considered a right that only the client can waive. And it extends to communications that are held between an in-house corporate counsel and a corporate employee. In France, the attorney-client privilege arises from utterly different origins. So it is part of the French criminal law and the ethics rules to protect not the client, but professional secrets. So under this conception, the obligation to protect such a secret is the duty of the attorney. It has nothing to do with the client. And it's considered to be a matter of what would call, if one translated it literally public order. So this is the term that is used in international law in French, even in the United States, all over in international law, l'ordre public. The translation you always see in English is public policy, but I think it's something more than public policy. It's something sort of fundamental, necessary for the system to continue. So a matter of real importance. So as such, it's not up to the client to waive such a matter. Because this is confidentiality that attaches to professional secrets. It's only in the lawyer's domain to decide, first of all, what constitutes a professional secret. Only the lawyer has the education, the knowledge, the know-how to make that determination, and as a result, what can and cannot be disclosed. And another big difference between the two systems is that, unlike in the United States, any communication between an in-house counsel and corporate employees are not considered privileged. So this is another big problem with discovery, is that, you know, many things for the French, had they only known about discovery, they might have, you know, not put things on paper. I mean, so now this is actually not a good logical consequence of what I've just said, but in other ways, because the French are not prepared for discovery, there are many things that, had they been, they would not have put in writing, whereas the US counsel would be very leery of putting some things in writing and making a paper trail. So where French and American parties resolve disputes through international arbitration, one of the things they find is that the IBA, the International Bar Association, says that it approves of respecting the attorney-client privilege. But the problem is, they don't say whose meaning of the attorney-client privilege is going to be given respect. And so this uncertainty has quite a big impact on the process by which trial preparation and evidence is prepared. In the United States, not only do US attorneys interview witnesses before trial, but they prepare them for giving testimony during trial. They go over with the witnesses both the testimony and the issues that are likely to arise during their own examination of them, during a likely cross-examination of the witnesses. So in France, such kinds of witness preparation is absolutely forbidden and is, as I mentioned earlier, nothing less than tampering with a witness. So in international arbitral proceedings, counsel normally are allowed to speak with witnesses about what they will testify to. The obvious concern, though, is to whether communications between an attorney and a witness would be subject to disclosure. But there's no established framework to govern this. And there's also no established framework to say, to establish a conflict of laws decision on this issue. So a French arbitrator might allow a French lawyer to inquire about communications between the United States attorney and his or her client. The other very, very fundamental difference between the United States and France has to do with evidence and how evidence is presented. So testimony is presented orally through witnesses in the United States. There is no such so we have, of course, cross-examination. In France, there's no such thing as cross-examination. And so they absolutely dread having to do this in international arbitration because it takes preparation. So in international arbitration, American lawyers also feel that their hands are somewhat tied because what happens is that they are not allowed to generally conduct full discovery. The discovery is quite limited. And so they feel that they're entering cross-examination in a kind of blind way. So their hands are tied. They feel that how can I go into a cross-examination? How can I go into an oral proceeding without knowing exactly what the witnesses are going to say? And sometimes in international arbitration, they follow the French procedure, which is not to have any witness testimony. Normally a French trial has no oral testimony whatsoever. Everything is in writing. But in international arbitration, the writing of witnesses can be very general. It depends on what the arbitral tribunal will require. If that's so, the US attorney has very little idea of how the witnesses will testify. So there's just one last privacy matter that I thought I would just raise, which is the prohibition on information gathering and dissemination in France. So this has become a very prominent issue today because of problems with minority populations and issues of discrimination against minority populations. And so many people in France are saying we need to collect data on race, religion, ethnicity. And that such data collection and dissemination is prohibited in France. So there is a constitutional value of color blindness and religion blindness in France. There was a recent study of diversity among French judges, or lack of diversity among French judges, that was conducted. And most prosecutors, when interviewed, were very offended by questions about diversity, and their response was, "We are all French." And the idea of being simply and only French in the public sphere is a deeply rooted value in France that has two origins. The first is the 18th century. This is Rousseau's idea from the social contract, where the individual trades into individuality in a common valued society and becomes the citizen. And as a citizen is a totally equal citizen with all others in the public sphere. And that's the idea of the state that then becomes very beneficent and powerful. But France then is one and indivisible. And any child in France will learn that from first grade on. France, one and indivisible. So une et indivisible for those of you who know some French. And to this older tradition, there has been a more recent one, and that is the Second World War. Under the Nazi occupation, it was required for there to be the collection of data about who was Jewish. And so, for example, all Jews were required to show up at the police station and register as such. And they were told nothing is going to happen to you, but you won't get ration cards for food coupons if you don't register at the police station. And so most people did, even though they were already a little wary, because this was in 1941. Already in 1940, the French version of Quisling, Marshal Pétain, had been proclaimed his wish to collaborate with Hitler. But so they show up, and then, of course, this is the prelude to all of the Nazi measures that will deprive them of their property and then eventually lead to knowing where they live and to the roundups that lead to their deportations to death camps. And so the lesson learned from that is the government has no business knowing anything like that. So the census in France is not allowed to ask questions about color, race, ethnicity, and as a result, even the size of the minority populations is a matter of some debate in France.